So good evening and welcome. My name is Joanne Camaford, and I'm a member of the City Bar's International Human Rights Committee, as well as the Associate Director of the Human Rights in the U.S. program at Columbia Law School's Human Rights Institute. And I'm pleased to be here with fellow committee member and organizer Susanna Phillips, who's the legal advisor at Women Enabled, as well as other colleagues from the Institute. And we're thrilled to welcome you to tonight's CLE program. On behalf of the International Human Rights Committee, the Human Rights Institute, and our City Bar co-sponsors, the Council on International Affairs, the Immigration and Nationality Law Committee, and the UN Committee. It's a privilege and an honor to have Gay McDougall with us today as a keynote, along with a truly inspiring panel of human rights advocates. And we're really grateful to all the speakers for making the time to be here today to discuss using international human rights strategies to effect change in the United States. And we're even luckier than I previously thought because Gay has joined us despite the fact that she has a flu and laryngitis. So it was a little touch and go there, but we got her to come out, so we're really excited. And before we introduce our keynote, I also want to thank Helen Herman, Anilsa Paredes, Linda Kemble, and the City Bar staff for really working with us to make today's event possible. And just a few words to sort of situate tonight's event for you. This exciting program is going to focus on both why and how U.S. lawyers are increasingly looking to promote human rights compliance within the United States, in essence, to bring human rights home. And our speakers will talk specifically about using international human rights norms and strategies in their legal work based on a common understanding that universal human rights values, including treaties the U.S. has ratified, as well as the Universal Declaration of Human Rights and U.S. human rights commitments, provide an important touchstone for both policymaking and for legal advocacy. And our goal is really to offer just a snapshot of the way that over 800 U.S. lawyers are using human rights to advance social justice and accountability, including members of the audience here today. And our CLE speakers really represent a cross-section of the domestic human rights movement, which is made up of remarkable and innovative advocates and attorneys who are turning to the human rights framework for a number of reasons. Because it offers new tools and new venues to seek justice. It represents new ways to frame and address inequality. It offers a common language for movement building and organizing. And it's also an avenue to seek accountability when remedies are exhausted in the United States. And this is work that lawyers across the United States have really been doing for decades, including our committee. But the last CLE on human rights here at the City Bar was in 2009, and a lot has changed since then, including growth of the U.S. human rights movement. So we're thrilled to have this space to explore the current landscape around domestic human rights lawyering, focusing on issues of maternal health, solitary confinement, migrants' rights, the death penalty, and national security. Indeed, lawyers, including members of the private bar, law school clinics, and local, national, and international NGOs and bar committees around the country are using human rights standards and strategies to address these and other issues. And we've dedicated some time at the end of the panel discussion really to talk about ways that folks in this room can begin to join and support these efforts.
So just a few logistical points before our program begins. We wanted to let you know that there will be two portions of Q&A during the program, one following Gay McDougall's keynote speech and then another following the panel. So if you have questions, there will be an opportunity for a dialogue with the audience. After the final Q&A, we're going to have a reception with some wine and snacks, so we hope that you will be able to stick around and join us for that so that we can continue that conversation. If you're receiving CLE credits today, please make sure that you have signed in for the program, and please make sure to sign out as well at the end of the program, and you will receive the certificate for your CLE credits as you sign out. They have them printed already. The event is being recorded, and it will be available on the City Bar. I'm not sure the timing on that, but I'm sure you will be able to find it there shortly after. And then finally, there is a hashtag for tonight's event, so anyone using social media, you can find the hashtag on either of the screens. And so we would really encourage you to use that for your social media tonight. And now I'm going to turn it over to the chair of the City Bar's International Human Rights Committee, Professor Anil Callahan, to introduce our keynote speaker. Thank you.
Thank you, Susanna and Joanne, for all the hard work that you have been putting in to make this event happen. It's been a long time in the planning, and it's an important discussion for us to be able to have within the City Bar as an institution. I have the honor of being able to begin to introduce as our keynote speaker someone who is one of the preeminent global experts on human rights. Professor Gay McDougall is currently a distinguished scholar in residence at the Leitner Center for International Law and Justice at Fordham University Law School. She is an internationally acclaimed scholar, activist, and attorney whose accomplishments over the years are far too extensive to enumerate in full right now, so I'll just point to and highlight a few of her many accomplishments. So in addition to her work in countries around the world, Professor McDougall currently serves as an independent expert on the UN Committee on the Elimination of Racial Discrimination. She has previously served as special rapporteur focused on the issue of systematic rape and sexual slavery-like practices in armed conflict, as well as the first UN independent expert on minority issues, which is a position that she held for 14 years. She's one of the few U.S. lawyers with such an impressive record at the United Nations, but her credentials as a human rights expert do not stop there. Her career has included work in private practice, in academia, government and civil society organizations as well. She has served as executive director of the international NGO Global Rights, where she collaborated with human rights advocates in countries in every region of the world to develop strategies to enhance human rights and justice, including litigation, advocacy, and capacity building. She has also played an instrumental role in advancing racial justice in South Africa. She helped orchestrate the release of political prisoners during the apartheid-era regime when she served as director of the Southern Africa Project of the Lawyers Committee for Civil Rights Under Law. And she was subsequently appointed as one of 5 international members of the Independent Electoral Commission, which conducted South Africa's first democratic elections in 1994, which of course led to the election of Nelson Mandela as president. For this work, the government of South Africa awarded her the prestigious honor of the Order of the Companions of O.R. Tambo last year. Professor McDougall has also been at the forefront of the effort to bring human rights home by developing strategies to draw upon international law frameworks to address poverty, discrimination, and social exclusion here in the United States. She began speaking up against injustice in the United States, of course, at an early age, having been raised in Atlanta during the Jim Crow era, and having subsequently become the first black woman to integrate Agnes Scott College, which formerly was an all-white Presbyterian liberal arts school in Decatur, Georgia. And she has long written and spoken about the relationship between segregation and discrimination in the United States on the one hand, and the resistance by the United States to international human rights treaties on the other, as well as the relationship between civil rights and human rights more generally, and the ways in which a human rights-based framework to combating discrimination and inequality might strengthen U.S. law and policy. She continues to participate in movement building, and to speak out in order to address pressing human rights issues. And it is such a tremendous privilege for us to have Gay McDougall here with us to kick off this event about the role that international human rights standards and strategies can play. I can't think of a more perfect person to initiate that discussion for us tonight, especially given that you were here under the weather. We really appreciate it. So with that, I'm very pleased to turn the floor over to Professor Gay McDougall.
Well, thank you very much for that introduction. I would say that perhaps you did far too much research on that. But I am glad to be here, and I want to take every occasion that I can to support a movement that I very much believe in and have been a participant in. And I really want to thank Joanne and Susanna for your efforts here, but also for the work that you do on a regular basis, because it's been essential to moving all of this forward. So what do you do as a keynote for this? Because I know you're going to have a panel of experts that are very much involved in the details of every inch of this movement now. I know them well. Actually, I feel like we're engaged in a sort of, dog and pony show around the country, maybe even around the world. But anyway, I do want to also take an opportunity to lift up the work that all of these organizations are doing. I just thought I'd make 2 points that are, to me, sort of central, and they're general points, and I want to engage in a back and forth with you, because it will really be helpful for me to know what it is that you have in mind and that you're thinking. I want to encourage lawyers, and I have for a while now, to integrate international human rights into strategies that address the important work that we all engaged in communities across the country. Now, why? Okay, there are 2 big reasons why that I want to speak to today to cast an overview of this. First of all, the idea of borders and jurisdictional limits and the divides between what we traditionally call domestic and foreign, I think we all now are clear that this is an obsolete notion. We still hang to the words of it, but it's gone. Shelf life has run on this. And I think, yes, most people in this room know it in other contexts, but not quite in terms of rights. What we've not figured out yet is how we can transform the way that we think about everything to make it in sync with this reality, this paradigm of being no real borders, no real jurisdictional limits. We have got to let this reality reshape how we think about rights and justice, racial discrimination, and how we do this work and how we move forward. In today's world, social problems like racism, particularly like poverty as well, are complicated affairs. Globalization has created a world in which, we are inextricably linked to people on the other side of the globe. Our economies are linked, and so too our social problems. And so I think we all realize now that there's no way to really address any societal problems on the ground here or in another country without at least referring to the global context that those problems arise in or maybe are controlled by. Increasingly, the global issues that determine our lives and how we live are decided on the international level. The WTO, the IMF, the G8, the G20, maybe all those are extinct now also. But that's where decisions are being made that ultimately are going to impact how we live on a daily basis, whether we have jobs, if so, what sector they're in, how much we'll pay for a cotton dress or a loaf of bread. And so these are not battles, I think, that we know that we can win through advocacy within, solely within the national borders of one's home countries. No one country's civil rights laws are really going to get at the solutions. So I think we've got to understand how to frame our issues in our domestic struggles in a way that resonates around the world in other cultures in order to get the kind of allies that we need to move this this work forward. And that's what a human rights framework does for you. It allows you to speak a language about your problems that is understood in other countries and at the international level, and which moves you away from the fallacy of the divide between domestic and jurisdictional issues. Second, I want to say that over the time that I've been doing this work, I have really seen that U.S. involvement and leadership in the international human rights system matters and has positive impact. I wouldn't have said this, a couple of decades ago, but I really have seen it in my career path. The U.S. is very influential in cultures around the world, in legal cultures particularly. And in doing that, it means that we've got to get involved on the level of lawyers. Lawyers have to be involved in this international struggle at all levels. It's interesting to me that the origins and the early development of the movement that can legitimately call itself the human rights movement is bound in interesting ways with the history of this country. I was just reading this weekend a book about the abolitionist movement in the United States. And how, 100 years before the UN was born, the abolitionists in the US were using the term human rights as a way of framing their struggle against slavery in influential ways. And they struggled, they used the human rights label in the courts, in the streets, in children's stories, in culture places. So, abolitionists really, and the African American community, really framed this struggle against slavery as a cross-border, as a transnational, as an international struggle for human rights, as it was. As we fast forward to the 1940s, I think we all now are aware of the role that Eleanor Roosevelt played in codifying, if you will, for the first time, human rights in the UN Declaration on Human Rights. But you know, that was, when she did that, she took the template from a speech that her husband had made during his presidency on the 4 freedoms. And that, in turn, was taken from a memorandum from the ABA to President Roosevelt. So, you know, we're all in there. And so I think that we have a responsibility. At the same time, let me just point out also that W.E.B. Du Bois and the leadership of the African American community was there at the start of the UN lobbying for the language to be included in the UN Charter about human rights. Why? Because he thought that this would create broader, more expanded rights for Black Americans, and that the UN would create or be other forums in which we could argue for those rights. And although Du Bois, his own first attempt at holding the U.S. Accountable in the UN, his first petition and those of the other African-American organizations like the NAACP, these first petitions were buried as a Cold War tactic. But nevertheless, he was right. The UN Charter, the Declaration on Human Rights, the covenants that followed, the treaties that followed, the many mechanisms that have been crafted within the UN human rights system do very definitely expand the rights of African Americans and all Americans struggling for a level of equality, dignity, and respect in this country. Clearly, it is broader than U.S. law in lots of ways that I'm sure the panel is going to talk about later. And it certainly has offered us a very important extra forums in which to raise our issues, to internationalize our concerns and our struggles. But it took almost 30 years before U.S. lawyers and activists could get involved at the UN, because it took that long for the U.S. to ratify some, very few, but some, of the key treaties, human rights treaties, and for us to be able to get in there, you know, and start to use them as we should have. You know, when I was first elected to a, oh, there's Ginsburg. Yes, sorry. I like that. When I was first elected to a human rights body, this was 1996. It was so radically different than today. It was, I would say that there was virtually no American lawyer, especially a non-governmental person, hardly, you know, the U.S. government participation in any of the mechanisms in Geneva. And one of the consequences was that when I got to the UN, there was almost no reference to a human rights issue inside the borders of the United States. Almost none. Never mentioned in the human rights resolutions that were coming out of UN bodies. And so, you know, the U.S. was very opaque looking at us from the outside. And there was great assumption that everything was all right here. The other thing is that it created such a skewed picture, of the international, of the global human rights concerns. Because all of the resolutions were focused on developing countries. So, you know, that asymmetrical, you know, picture that was created by that almost collapsed the whole system. So I was one of the earliest voices saying that we must change this. And the change must come from the level of civil society and U.S. Lawyers. So it began very slowly, this call for bringing human rights home. And with the great push from the U.S. Human Rights Network, the formation of the U.S. Human Rights Network, from the creation and the work of organizations like the Columbia Law School Institute, we began to make our views known in two ways. One, we started crossing this country and helping communities use the language of human rights and the foundation of the framework of human rights in their daily struggles on the ground, and to be able to get momentum from that. And secondly, the faces of American civil society members and lawyers started to show up in Geneva. And so now we have the situation of hundreds of lawyers and civil rights activists from this country going to the UN in Geneva every year. One consequence of that is that the view of human rights in the U.S. has radically changed in the international community. The other consequence is that we, all of us, have contributed to the understandings of things like racial discrimination. You know, we have invaded the conceptual lexicon of, you know, human rights bodies in the UN. So they're now talking about, you know, policing and how there is, you know, how there is institutional and structural racism in countries, racial profiling. All of that has come from our impact on the system as well as the system's then impact on us. So the benefits have been in two directions. The other thing, I know I'm running out of time, has been it's created a demand side, you know, increase in pressure, so that the U.S. government has said, oh, we got to get involved. And so we have seen now, particularly since the Obama administration has taken this on, we've seen an increase in the substance of their submissions to the UN. We have seen an elevation in the, you know, the players that they send to respond to the periodic review hearings. And so it's created a different level of engagement by the U.S. government. I hope all of those things continue because they are as yet imperfect, and there's a lot of work to be done. I will stop there, but I will ask if, do I do the asking for questions? Is that, because I do want to hear questions and issues from your side.
Thank you so much, Gay. For anybody who has questions, we have a microphone here, so if you could go ahead and come up to the microphone, because we are recording this, we would like to make sure that the questions are also heard on the recording. So we'll open it up to a few questions before we move on to our panel.
Hi, I'm wondering, with your experience with international human rights, what would you say to practitioners and lawyers here in the U.S. who haven't fully understood the value of using international human rights? Is there a particular issue where you can show how international human rights and the work done in the UN made a difference and made a win for lawyers here in the U.S.?
Well, first of all, I would say what I just said to all of you. But yes, there have been, explicit remedies in the way you're talking about. But, one of the things about engaging the UN and this framework is that the outcomes are different. I can't say that, nor would I like to hear that the UN has overrule some U.S. statute. That's not the way this goes, as we keep telling the Senate. This is a focus more generally on mobilization, on changing the perceptions. I would say that we've had a shift, a normative, attitudinal shift in the last 20 years, where people like our great Justice Ginsburg and others have recognized the importance of connecting with the world and seeing the benefits of human rights values and how they might strengthen their own work and conclusions and decisions at the UN. We've seen a lot of city governments taking on these standards and making them real and incorporating them into city law and tagging to the money, making budgetary lines so that there can be real fulfillment and implementation of this. So I think that we've seen some real wins. But, I think it's very important that lawyers and communities not believe that this system is about, going beyond the courts in the U.S. for one more level, although that is the case in some situations, not for the U.S. The U.S. has not signed on to the optional protocols of any of the treaties, which would afford U.S. citizens an opportunity to take their specific issues to one more stage of decision-making. But so far, the U.S. has blocked that as an option.
Speaking in terms of procedures, since we don't have access to those protocols, are there specific steps or other things that lawyers might do if they have civil rights concerns or human rights concerns in the United States that they think might benefit from a more global hearing?
Well, there are a lot of global hearings available for U.S. communities and lawyers. I was just reading whose piece on the Inter-American Commission on Human Rights, which regularly holds hearings to which people in the United States and other countries, of course, can bring their concerns. And actually, lawyers and the U.S. lawyers can shape the hearings so that they speak specifically to the issues in their representation of communities. Same at the human rights mechanisms in Geneva. In fact, the hundreds of lawyers and community members that have gone to Geneva have gone in the context of something that's a little bit like a hearing, of treaty bodies, before treaty bodies, where U.S. government representation now is significant, and it gives these organizations and lawyers an opportunity to speak to those government representatives in ways that they're not often able to do here. So issues have gotten elevated to federal, if you will, national concern that would otherwise be sort of buried at local levels.
And our panel will also address some more of the strategies, more of the specific strategies that advocates are engaging in now. So if there are no more questions, I think we'll invite our panelists up here and say a very kind thank you to Gay for rallying tonight and for your really inspirational remarks on the importance of U.S. engagement with human rights mechanisms. Thank you so much, Gay, and I'll invite our panelists up. So we're very pleased this evening to have as a moderator Risa Kaufman, the Executive Director of the Human Rights Institute at Columbia Law School. Risa is a formidable human rights advocate whose advocacy, research, and writing focuses on domestic human rights accountability, access to justice, economic, social, and cultural rights, and implementation of the UN Sustainable Development Goals. And her more detailed bio can be found in your CLE materials. Thank you, Risa.
So good evening. Hi, everyone. So as Suzanne said, I'm Risa Kaufman. I direct the Human Rights Institute at Columbia Law School. And I'm really thrilled to be here moderating this conversation on the use of international human rights strategies to affect change in the U.S. I want to thank the City Bar and the International Human Rights Committee for organizing this event, and to the co-sponsors also. And I really want to thank Gay McDougall for her inspiring and illuminating remarks. Professor McDougall really is an inspiration to all of us and really inspires the work that you're going to be hearing about this evening. So I have an honor and the privilege of facilitating this conversation among three people who I consider both colleagues and friends, who, along with Gay McDougall, have basically taught me everything I know about human rights in the United States. Vince, Jamil, and Katrina are longtime U.S. human rights advocates, and they're at the forefront of efforts to innovate human rights strategies to advance social justice in the United States. I'm really excited for the conversation that's ahead of us. I'll introduce each of our panelists more formally in just a moment, but first I want to take just a few minutes, if you'll indulge me, to contextualize our conversation, to really situate this. So this evening we're going to be discussing how U.S. lawyers can use international human rights strategies to affect change here in the United States. Undergirding this conversation, of course, are international human rights standards, which you've heard alluded to so far this evening. So we thought it would be useful just to take a step back and define what we mean by human rights standards and make clear how human rights standards and treaties are relevant to U.S. lawyers. So just a little bit of Human Rights 101, if you will. So since the UN's adoption of the UDHR, which sets forth the framework for the protection of all rights, economic, social, cultural, civil, and political rights, the U.S. has ratified 3 major international human rights treaties: the International Convention on Civil and Political Rights, which protects basically the rights contained in the U.S. Bill of Rights, the Race Convention, or the CERD, which protects against discrimination of all rights, and the Convention Against Torture. The U.S. has also ratified the Genocide Convention and 2 optional protocols to the Children's Rights Convention, one on trafficking and one on child soldiers. We've signed but not ratified several additional human rights treaties: the Women's Convention, the Children's Rights Convention, the Disabilities Rights Convention, and the Economic and Social Rights Convention. In addition to participating in the UN Human Rights Treaty system, the U.S. participates in the Inter-American Human Rights System, which Professor McDougall discussed, through its participation in the Organization of American States. So the American Declaration of the Rights and Duties of Man is also relevant to our conversation here. So a natural question is, what is the status of human rights treaties in U.S. law? A very, very broad brush. With respect to treaties the U.S. has signed but not ratified, the U.S. has the obligation to not act in a way which would defeat the object and purpose of the treaty. With respect to treaties that the U.S. has ratified, they're binding under the Supremacy Clause, but of course the U.S. ratifies treaties in a way that dilutes and limits the impact and the applicability of the treaty in U.S. law. Most pertinent to our discussion, the U.S. ratifies treaties with something called the Declaration of Non-Self-Execution, which means that a treaty can't be directly enforced in U.S. courts unless Congress enacts implementing legislation. Now, while ratified treaties aren't generally enforceable in U.S. courts, they still have very important domestic and international impact, which is why we're here today, of course. So the U.S. has the international legal obligation to abide by the treaties it's ratified, and it must periodically report on its compliance. The U.S. participates in human rights reviews by the UN Human Rights Council, the Universal Periodic Review, and it appears before the Inter-American Commission, as you've heard. So there are many ways other than direct enforcement actions in which U.S. lawyers can seek to hold the U.S. accountable for its international obligations in U.S. and state courts, in policy advocacy at the federal, the state, and the local level, through the UN and Inter-American Commission and mechanisms, and through grassroots advocacy. So you're going to hear about many of these strategies from our panelists. In fact, in recent years, there really has emerged this growing movement, a growing number of U.S. lawyers and advocates who are using international human rights standards to advance their U.S. advocacy. As Joanne mentioned, the Columbia Law School Human Rights Institute is really privileged to facilitate this network of lawyers, the Bringing Human Rights Home Lawyers Network, which is over 850 U.S. domestic and social justice lawyers who use international human rights norms and strategies to advance social justice in the U.S. Vince, Jamil, and Katrina and their respective organizations are real pillars of this network, and I'm really thrilled that we're gathered this evening to talk about their work and the strategies that they use. So I'm not going to provide detailed introductions. Their full bios are in your materials, but very briefly, Vince Warren, who's in the middle, and we'll go first, is a longtime civil rights activist and currently the executive director of the Center for Constitutional Rights, which has really been at the forefront of cutting-edge civil and human rights advocacy and movement lawyering in the United States since the 1960s. Jamil Dakwar, at the end, is the founding and current director of the ACLU's Human Rights Program, which is innovating the use of the human rights framework in the ACLU's domestic human rights advocacy on issues ranging from national security and racial justice to women's rights and immigrants' rights. And finally, Katrina Anderson is the Senior Human Rights Counsel at the Center for Reproductive Rights, where she leads the center's work to integrate international human rights strategies into domestic legal advocacies on issues related to reproductive freedom. So thanks to all of you for being here. And what we thought we would do is we'd jump right in. I'm going to pose a couple of questions, and hopefully we can have kind of an interactive dialogue here. And then we'll have time for questions from you all. So I thought I'd start with a general question. So we've talked about the fact that the U.S. has ratified important core human rights treaties. They're not, for the most part, enforceable in U.S. courts, but you've heard repeatedly, and we've talked about how there are increasing numbers of ways in which U.S. lawyers are finding ways to integrate human rights into their work and broadening our understanding of U.S. accountability for human rights. So I'm hoping if each of you could just share an example of how the human rights framework has strengthened your domestic legal and policy advocacy, perhaps focusing on a specific area. You can speak from your seats, or if you want to come and take a stand.
Oh, I'm going first.
Vince, you want to start?
Sure, I'll start. Thank you very much, Risa, and hello, everyone. It's wonderful to be here, and particularly on this panel with such wonderful people. Strangely enough, I'm going to start off with the concept of the bus. And the reason why is, as I was sitting here listening to Gay, I realized that the first time I ever met Risa many years ago was on a bus. We were on our way to a civil rights conference. First time I ever met Katrina was on a bus. I don't remember where we were. And I've been on buses with Jamil. You know, more in various countries. And I guess sort of continuing with a very strained bus analogy, one way to think about how we at CCR employ human rights strategies is that a civil rights strategy or a constitutional law strategy and a human rights strategy are in two different seats on the same bus. And it's important, I think, as we've heard from Gay, how the field has really developed significantly since 1996, certainly. It's important to think about these as complementary strategies leading towards the same result. One thing I'll say before I go into my example is that I've been struck by Gay's words, I think both tonight but in previous discussions. And one thing that she had said back in July when we were having a conference on law for Black lives, and she was leading an international human rights panel, she said that the problems of race that we face in this country at this point are larger than any domestic mechanism we have to solve it. And I think Gay said something along those lines when we were thinking about jurisdictional issues. And I agree very deeply with that. The level of the domestic human rights problems that we are solving are large. And for those of you that practice, particularly in constitutional law, know that the ability to affect them meaningfully and deeply is somewhat limited. So an example that I would want to give you of how we employed two different tools on the same bus is the Center for Constitutional Rights challenge to solitary confinement in California. In May 2012, we raised a constitutional challenge to prolong solitary confinement as a federal class action complaint on behalf of prisoners at California's notorious Pelican Bay SHU facility, where prisoners were confined to windowless cells for between 22.5 and 24 hours a day. There's plenty written and there's plenty to know about the effects of solitary confinement. But the reason why I think it's important for this discussion is that one of the big challenges for us was how do we employ both an Eighth Amendment challenge regarding cruel and inhuman punishment, and how do we make that different from the previous Eighth Amendment challenges that had been done in California? The most recent one was settled in 1985, and people were still in long-term solitary confinement. And so what we did was looking at the human rights norms, particularly around the Convention Against Torture, during the Special Rapporteur system, the Special Rapporteur on Torture at the time, Juan Mendez, who had gone around the world and had interviewed people who were in solitary confinement and done research, and by the way, was not allowed to go into Pelican Bay Prison. I'm just saying, that's how the U.S. operates. But he went to a lot of other places and determined based on his research that after about 15 days, in that kind of isolation, after about 15 days, that conditions began to be present in the person that really amounted, that was tantamount to torture. And those were the psychological conditions. People, of course, were beginning to lose mental facilities, that they were becoming disoriented, they began to have headaches, and all sorts of things that you know. But that raised an interesting challenge, which is in an Eighth Amendment context, how would you convince a federal court that 15 days is the threshold for, under an Eighth Amendment analysis, for the limit to solitary confinement? And that particularly because at Pelican Bay, there were hundreds of prisoners that were held in solitary confinement, hundreds that were held in solitary confinement for over 10 years. And in our plaintiff class, 78 that had been held in solitary confinement 22 hours a day for over 20 years. And so our thinking was that one of the differences that I think Gay pointed to between thinking about constitutional law and human rights is that the constitutional analysis largely rests on a balancing act between the rights of and the intentions of the government and the effect on people. It's a balancing act. And so in that balancing act, in an Eighth Amendment context, you can imagine how courts could find all manner of really terrible treatment to be reasonable for the penological interests of a prison facility. The human rights framework looks at it very differently. It looks at it from the perspective of the person, and it matters less why the government did what it did, and it matters less what the justification was. It matters more what the effect of the policy was on the person. So what we did was we filed the cases and we litigated the case in the context of the Eighth Amendment, but a range of our amicus briefs and a range of our supporting materials and even our interventions with Congress were focused not just on the Eighth Amendment context, but they were focusing on the human rights context. The idea that this is solitary confinement is something that other countries are taking much more seriously than the United States. As a result, we were able to get a fabulous settlement in the solitary confinement case where the state of California, although they didn't reduce it down to 15 days, has moved most of the men that we've had in long-term solitary confinement out and has limited the amount of time that they're going to be kept in solitary confinement in the entire state of California.
Thank you, Risa, and thank you for hosting this event. I'm very delighted to share the podium and this panel with friends and colleagues. I want to continue with some of the things that Gay said, because I think she did make a remarkable point about the history of using international public opinion, not just international law, because international law, it is also a matter of reflection of public opinion in a sense, because it has formed based on the notion of what countries, what nations have believed has been important enough to bring it to an agreement between nations. And one thing that reminded me when she mentioned how abolitionists in the history of the United States have used the terminology or used international or human rights to one of my favorite quote from Frederick Douglass when he gave a speech, one of the two speeches that he gave after the Dred Scott decision by the U.S. Supreme Court, and where he said, and that was in, I had to look it up just as you were mentioning that, because I think it's really important to use here. So he gave that speech at Rochester, New York on May 14, 1857. And he said, one of the things that he said, in response to the U.S. Supreme Court closing the door, or basically in that infamous decision, he said, you may close your Supreme Court against the black man's cry for justice, but you cannot, thank God, closed against him the ear of sympathizing world, nor shut up the court of heaven. And clearly there is a very strong understanding of that the rights are not just emanating from the domestic system, as we call it now, or the constitutional framework, but it is really broader than that. It is more inherent in human beings, and which really the UN Declaration on Human Rights from 1948 brilliantly reflected or stated. So with that, I think we can talk more about the more recent way of particularly using or invoking international human rights or foreign law in order to push back against very serious policies and practices that the United States, particularly in the area of national security, and I think first we want to give credit to a lot of the advocates and lawyers who did that on day one, people like Michael Ratner from Center for Constitutional Rights and other lawyers who, as the United States started to build post 9/11 Guantanamo and sending individuals to Guantanamo with no access to U.S. courts, no access to lawyers, no access to the outside world, they have immediately went back to the fundamentals of habeas corpus, the fundamental of human rights, of international legality, international rule of law, and invoking Geneva Conventions, international treaties that the United States signed on and ratified, and been recognized internationally as even customary international law. And in those kind of situations remind us of the limitation often of the constitutional system, limitation of international domestic law in protecting particularly vulnerable communities, protecting minorities. It happened in World War I. It happened, well, you can go back as far back as Abraham Lincoln's issuing, suspending habeas corpus of censoring the press, doing all kinds of things during that very period of time, but also more recent, in World War I, World War II, with resorting to policies of interning Japanese Americans based on security reasons. And I think what we've seen is that thinking about thinking about challenging those policies was not enough to frame the issue only as a constitutional frame or statutory frame, but also as international legal frame that would also encompass the ethical, moral obligation of the United States, not only the legal obligations. And even if they are not legally binding in a way that we would want them to see, they still carry out a lot of weight. David Cole just came out with a new book called The Engine of Liberty. And I haven't read it yet, but in a synopsis that he just published in Just Security, he talks about how the pushback against national security policies post 9/11, particularly by civil society organizations, by human rights advocates from the United States and from abroad, was important to frame or to push the United States Supreme Court into the decisions that it took in Rasul, in Hamdan, in Boumediene, and other cases that were made. And they were not necessarily, all these cases, of course, they were decided after litigation and after arguments, but there was a lot that was happening outside the courts that we need to pay attention to. And that effort is an important one because it also made even the Bush administration start to roll back on these policies when they felt that there was a lot of international pressure coming from all over the world. When human rights advocates were going to Geneva, to the United Nations Committee Against Torture, to the UN Human Rights Committee, to working with UN special rapporteurs and experts on torture, from that time, building an international pressure based on the foundations of international human rights, assisted in a way of shaping and leading to rolling back on some of these policies. So while we still have a lot to do in order to make the United States in more compliance with at least the existing ratified human rights obligations, and we can talk more about the limitation on access to justice, which is one of the things that even if you ended a policy, unjust policy, for example, of ending torture, but without having access to remedy, effective remedy in U.S. courts, that would be a violation of international human rights obligations. And we can talk a little bit more about what are those challenges and how we can overcome them by using both innovative domestic arguments as well as complementary advocacy strategies, going to the Inter-American Commission on Human Rights, raising the issue constantly in different ways, bringing the experiences of other nations, Latin American experience with the dirty wars, with dictatorships and what happened there, as well as what's currently happening in other parts of the world, so that to kind of going back to Gay's point of building that movement that is connected together and thinking creatively about strategies to push back, but also proactively moving forward in making the law more progressive and closing the gap between law and what we really want to see, justice.
Thanks, Jamil. I just want to underscore this point about the complementarity of all of these strategies and how they're building on each other, right? And it's a conversation between the domestic and the international. Katrina, do you want to maybe move that forward with some of the work you all are doing?
Sure. Thanks, Risa. Hi, everyone. Thank you so much for inviting me here, to Joanne and Susanna. It's always a total pleasure to be on a panel with people whose work I've admired for a long time and has really influenced my work as well. So I want to also just begin by saying how much I appreciate the way that this panel was framed as advancing human rights strategies domestically, because I really think that that signals a difference in where we were maybe 10, 15 years ago, when the conversation was really around how do you domesticate international law, how do you cite to treaties and briefs. I really think that we've grown a long way as a movement since that time and have started to expand our understanding of what using human rights really means, to include taking advantage of different forums, using the mechanisms, and highlighting the strategies that I think have been developed by so many different sophisticated advocates all around the world and really have a lot to teach us here in the United States. So I want to focus on a campaign that we've launched at the Center for Reproductive Rights that focuses on economic, social, and cultural rights. So pretty different than what we've heard so far. And you know, I know that there's a lot of discussion about the justiciability of economic, social, and cultural rights in the US, and so I think that this campaign is an interesting model of trying to advance through state and federal policy some of the human rights norms to think about justiciability in a different way. How do we try to advance economic, social, and cultural rights here? So this campaign is called Nuestra Texas. So it's a campaign that's focused on South Texas, and specifically the lower Rio Grande Valley, which has seen in recent years the most severe impact of some of Texas's harsh reproductive health policy laws that they've passed. So long before the HB 2, which was enacted in 2013 and the subject of a recent Supreme Court case brought by my organization, Texas had begun to basically target reproductive health services that serve really low-income women. So I'm talking about the family planning clinics that provide contraception, cancer screenings, testing for sexually transmitted infections. For women in very rural communities, they offer services on a free or sliding scale basis to women who have basically no other source of health care. And in an effort to, really it was an effort to sort of limit the reach of Planned Parenthood. It was a very political move. Texas began to target funding that went to these clinics. And almost overnight, about 40% of these clinics closed in the state. 30% more of the remaining ones experienced such severe cutbacks that they could hardly meet the demand. So we're talking about the virtual elimination of a health safety net that uninsured, poor, low-income women relied on for their basic care, not even just their reproductive health care, but just their basic care. And so we had a long partnership with an organization called the National Latina Institute for Reproductive Health, a national organization that has a strong chapter in Texas. And they began to bring these stories to us saying, we have all of these women who are impacted. We don't know what to do with this information. Can you help us? And we began knowing that it was unlikely that the fact-finding that we could do there would lead to litigation, given the lack of ability to bring claims in U.S. courts around these types of violations. But we did think that we could have a strong human rights campaign that could emerge from that. And that's exactly what happened, actually. So we worked with some social scientists who were able to do quantitative research, and then we collaborated with them to sort of fill in the gaps from a qualitative point of view, doing community-based participatory research and using human rights documentation methodology as well. So we were able, through that documentation, to put a human rights frame around exactly what was happening. So in fact, it wasn't just the fact that the women were experiencing violations of their right to health care because the clinics had closed. It was also a function of their lack of access to transportation, to child care, and a function of their poverty and their situation. So the many, linking this issue to to economic and social inequality was key. So we were able to identify the rights and then identify the obligations of government that flowed from that. For example, under human rights law, when you talk about the right to health, there's an obligation on the part of government to consult with and ensure that any cuts in services do not impact the most marginalized populations. So the right is framed as the right to non-retrogression, but there's a duty on government in order to ensure that government is not going to be targeting the most vulnerable people when they make these cuts. So our fact-finding report was able to frame the rights and obligations in a different way. And then the strategies that we used subsequently, we held a human rights hearing in the Valley. We were able to get a visit from a UN working group on discrimination against women to come to the Valley and to surface, again, to shine visibility on what was happening there. And then also to bring some of the women who were most impacted to Geneva and to these international spaces where they could articulate what was happening to them. So I think one of the results of this is in addition to really empowering the women leaders and furthering the community mobilization goals, we were also able to frame the violations for state policymakers in a way that was based on human rights and no longer solely on a cost-benefit analysis about family planning, that was then able to push state policy. So in the end, the work of this campaign was able to restore and actually exceed the original levels of family planning funding in the state, and also to keep the emphasis on the fact that immigrants and rural women need this access to care, and that's where the focus of the policy should be, not just generally with the women of Texas. So I'm out of time, but.
I feel like you could probably go on for another 15 minutes talking about this example because it's so rich and talks about the importance, it shows the importance of working with local partners, impacted communities, how the different mechanisms are building on one another, and what an exciting time we're at where we really can start to develop these examples in a more robust way and bring those recommendations from the international back into the domestic. So I find these concrete examples really illuminating. And Vince, I want to go back to you because the Center for Constitutional Rights is working in so many different areas. So you spoke first about solitary confinement. CCR is also doing really cutting-edge work on death penalty. And I'm wondering if you can maybe give us another example of ways in which your organization is using human rights strategies, particularly on abolition of death penalty work.
Yes, I'm happy to. So on the death penalty context, the context of the strategy in death penalty is radically different from the context of the strategy in solitary confinement. Why in solitary confinement, one of the main tools was a targeted Section 1983 litigation that had almost like wraparound services and sort of undergirded by this deep sense of human rights norms to which all people should be all government should be adhering to. The death penalty context was different because, number one, as you can understand, that the death penalty issues largely get litigated in the context of individual cases in individual states. Each state is different. Each state has a different set of rules. That the federal oversight and federal court oversight is minimal in the context of the death penalty than certainly it is in a Section 1983 case. And then the question is, as a strategy, who are you trying to convince? So in the solitary confinement case, clearly we were trying to convince the court. We were trying to convince Congress that had held hearings on solitary confinement. In the death penalty context, we had to decide which states we thought would be the best states to engage in. And we did a human rights mission where we partnered with FIDH, the International Federation of Human Rights, of which we are a member league, and the Center for Constitutional Rights partnered, and we looked at two different states. We looked at California, and the death penalty in California, and we looked at Louisiana. It's important to note that the people that we were trying to convince were not the people who were going to be able to make the decision to abolish the death penalty, which is largely governors or state legislatures. And the reason why is because those offices are so deeply political, and of course in places like Louisiana, trying to convince a state legislature, when you're coming in with like a dark suit from New York, trying to convince the state legislature that there's a human rights world out there, they're not really, it's not going to be so persuasive. But we had two targeted audiences that were a little bit different, and this is more in line of what Gay talked about, which is building the U.S. role in terms of civil society in the human rights norms. And so our two targets were the death penalty advocates in Louisiana and California, and the international death penalty advocates. Why did we choose the international death penalty advocates? It should come as no surprise that the death penalty internationally is a deeply discussed, strongly held issue where most states recognize that it is deeply inhuman. A lot of states have eradicated it, and they simply can't understand why the United States continues to do it. The other side of that is because the death penalty community in the United States is such an insular one for people that if you know anyone that does death penalty work, they build a wall around their advocacy because death penalty is different and that they don't want to have these other influences in their work. They want to keep their issues really tight and clean. But they're so insular that the death penalty bar had really no meaningful presence in the international community. So the voices of the people that were actually, and the clients and the family members who were deeply involved in fighting the death penalty had no relationship at all to the international community. So our strategy was to do this advocacy report and then hand it out and have conversations with death penalty advocates in those two states and to have a conversation with the international community. Without going into too much detail with the death penalty report, we looked at three issues in California and Louisiana. One was the arbitrariness of the death penalty. The second was the discriminatory nature of the death penalty. And the third is the conditions in which people are kept while waiting for death, each of which violated various protocols, the ICCPR, CERD, the Convention Against Torture, et cetera. I would conclude by saying, as this strategy, it was marginally successful. Marginally because in California at the time, there was a statewide proposition that was moving forward that had $7 million behind it to end the death penalty. And the death penalty advocates themselves did not see room in their strategy for bringing in something like international human rights. And so that if you've ever done these types of campaigns before, that's one of the things that you do is you figure out what your strategy is going to be. So we weren't very successful in integrating the human rights concept into that strategy. But what we were very successful in is once they lost, that a number of folks began to think, well, how can we think about incorporating human rights into our strategy for the next time? We were more successful in Louisiana insofar as that the Louisiana advocates, Louisiana is a different state where they've got what's largely a dormant death penalty. So they have a number of people that are on death row, but the advocates are quite good there, and they've managed to prevent a number of them from being killed. And the way that they do that is by essentially keeping the visibility of the death penalty bar relatively low, so that the politicians don't begin to think, wow, we have to completely execute more people. But they were very open to the idea of looking at international human rights. And even though they didn't deploy it legislatively, we've gotten requests from a range of groups because of the publishing of that report to help assist with amicus briefs where strategically the advocates want to raise human rights frameworks in the context not of Supreme Court appeals, but in the context of actual cases as they're moving forward.
Thanks, Vince. So your answer really surfaces a very important critical issue lurking behind a lot of this advocacy, the issue of federalism, right? So the federal government ratifies human rights treaties, but so many of the issues are really within the jurisdiction of state and local governments. Interestingly, we're finding a number of state and local governments are really quite interested in promoting human rights and integrating human rights. So, Jamil, I'm going to get to you next because the ACLU, of course, the national organization with state affiliates, you're working around the country at the state level. Maybe you could talk a bit about how federal, state, local issues play out with respect to human rights advocacy, particularly in the context of immigration, right? An issue that has federal and state dimensions. You can talk about a different issue if you prefer, but if you could talk a bit about how the federal, state, local advocacy all plays out in the context of human rights.
Of course, be happy to. I mean, moving to a subject that is not very different from the subject of the treatment of non-citizens in the context of national security, you're dealing with a situation of how the U.S. law is dealing with non-citizens in immigration or refugee asylum proceedings, because it's in those two things one need to remember that the constituency for these groups of people is very limited in the United States. While maybe in the immigration context, you'd have a much bigger constituency out there of the public to be rallying or supporting the rights or human rights of people in immigration detention or people in asylum proceeding. In the national security context, that was one of the most difficult things for human rights advocates to counter, is that you don't have the people who are out there other than speaking to the values of American people and the history of the United States of trying to promote human rights internationally and what that means, so on. But in immigration context, I think now the ACLU, there's not a case where it comes to a higher level of judicial scrutiny where you are not thinking about incorporating human rights amicus briefs. Because even if you are limited in the way that you can craft a legal argument to use direct invocation of international human rights, there's still a lot of ways that you can bring in the framework, the international human rights framework and standards and norms in human rights briefs. But I want to cite one example, which was a really very successful example, where we normally start with or resort to human rights documentation that Katrina talked about when we sometimes find it almost impossible to bring litigation, almost impossible to litigate and to use the court in order to change, to provide remedy. Either because we tried and lost, or it's just impossible to get into the door. And Eighth Amendment challenges was one of the areas where it's hard often to do that. But in the context of immigration, what we did a few years ago, it started with a human rights documentation of the rights of immigrants with mental disabilities facing deportation, and recognizing that people with mental disabilities meaning not understanding what is going on, what are they going through, and left to languish in prison for years on end. How do we document this problem, this phenomena? How do we put a human face? How do we use the storytelling of the people who are even hard to sit down and interview and to get them to speak to what happened to them? How did they get to where they are? But yet succeeded to do that through a human rights report that was published by the ACLU and Human Rights Watch, looking specifically on this community. But the result of that was not only to engage the federal government on trying to look at the right and access to counsel, not just in a criminal context, but also in a non-criminal context, which is a universally recognized right under international law. And some countries even use it in civil litigation as a standard. Take, for example, Germany. People who don't have access to a lawyer in civil matters, they can get a lawyer. Now, that documentation, that report, with a lot of the building the media attention and public opinion and federal government attention as well, and pressure on the fact that this is a serious human rights problem, brought a litigation on behalf of some of the individuals that were interviewed, and specifically led to a class action case to develop in California, which ultimately was concluded in a first-of-its-kind order by the federal judge, ordering the government to appoint a lawyer to those who were unable to understand the immigration proceedings and with mental health or mental disabilities during that process. Obviously, it was limited order. It applies to Arizona, California. But in a sense, it did create the space for a human rights documentation that leads into successful litigation. And ultimately, even during the immigration reform legislation that did not pass, there was actually, in the Senate bill, actually, it was included. We were able to push for that recognition even in that reform, which obviously did not go through. But you can see how you can build a human rights documentation, you can get it through a partial success in litigation, and then even take it up to the level of legislation, which ultimately, which is what you want to see. What Risa mentioned before is the lack of enabling legislation to translate international human rights obligations into concrete specific obligations by the federal, state, and local governments. So that's one thing. Other example that I want to quickly mention is the way that our affiliates, both lawyers and advocates who are not lawyers, used human rights advocacy and strategies on the U.S.-Mexico border to push against, really, the militarization of the border, human rights violations because of severe and harsh enforcement measures that were taken, and using human rights framework to look at family unification issues, how the migrant family communities have been affected by the separation, looking at detention conditions, involving the Inter-American Commission on Human Rights in coming to these communities and talk to communities and even press for visits of these detention facilities, and then engaging with the federal government on that. And also finding allies in communities that have not necessarily are with us on everything that we talk about human rights. One of the things that, just to give you an example, how sometimes you run out of everything, but maybe Vince will not like this example because of the CCR's very persistent advocacy against the Vatican on a very understandable and very important one. But I would say that in the first Universal Periodic Review of the United States in 2010 that Gay touched on, the use of the United States program of Operation Streamline, whereas individuals, migrants, are processed in mass. If you haven't been to a federal court in Arizona, in those jurisdictions where this program applies, you should find a way to get and see that, a travesty of justice, where they stand up all and they would have very limited time to consult a lawyer. They are being criminalized for illegal entry or re-entry, and then they will be sentenced, almost en masse. And that was a program that started during the Bush years and continued, and there was a push in Congress to even add more resources to this program. And during the Universal Periodic Review in 2010, the Vatican, the Holy See representative, took the microphone during the United States review and said, we have concerns about Operation Streamline, and we ask you to suspend that program because it violates migrant rights, something that the Vatican, the Pope, has been championing for years, not before Pope Francis' term. And that was something that was said on the record. And when the Congress was hearing, and members of Congress competing, who's going to get more money for this program, that was almost the only argument that we were able to use to push back against that program. Where we're advocates, we say, well, wait a minute, we remember that was made by the Vatican. If you agree with the Vatican on some things, or you think that there's a moral authority there on this, you really better listen to what the Vatican said about this program. And it was something that helped advocates in those kind of situations where other means were not really as persuasive, as compelling. This is just a way of connecting things that happen in Geneva to things that are happening at the border back to DC where the decision-making is happening.
I love that example. I feel like it really epitomizes the notion of a holistic advocacy strategy. But of course, litigation is still core to the work that we do as lawyers and U.S. human rights lawyers. And Katrina, I'm sure many people's minds are going to a very important case that your organization just argued at the Supreme Court on women's access to reproductive health care and access to abortion, whole women's health. Maybe you could talk just briefly about the role of human rights in that litigation.
Sure. I always try to get away from Texas, but I can't really. So back to Texas. So whole women's health versus Hellerstedt is a case that we argued for the Supreme Court to challenge HB2, which is probably the most restrictive abortion law that's been passed in the country to date. It has a number of restrictions. We challenged 2 of them that, if allowed to be enacted, will shut down all but 9 or 10 of the abortion clinics in the state out of a total of 40, more than 40, that existed before the law took effect. So it will have a tremendous impact on abortion access in Texas. And I want to talk about how we were able in a couple ways to use human rights strategies in that litigation, during the course of that litigation. So, we knew that we had a very difficult standard to work with. The current standard around access to abortion is the undue burden standard, where this is from Planned Parenthood versus Casey, where a court evaluates whether restrictions create an undue burden on a woman's right to access a safe and legal abortion. It's been interpreted very differently by many different judges, and we have argued in all of our constitutional litigation that the standard needs to be reframed and reworked. But knowing that we had this standard, we were trying to think about how we could use a human rights analysis to push judges to understand the practical impacts on women of what this law created. So instead of looking at just one set of impacts from one provision of the law, we needed to be looking at the cumulative effect of what this law did for women in Texas. And also looking at not just women in East Texas, or all women of Texas, but women in areas that would lose all access, and women who would not be able to travel to Dallas or to Houston or to some of the bigger cities in the eastern part of the state to access abortion if the law was went into effect. So we needed to help contextualize what this meant for women who were living in the South, in the area that I was talking about before, in South Texas, the Rio Grande Valley, where there's one remaining abortion clinic in McAllen, Texas, or in El Paso, all the way on the west side of Texas, and that's a 500-mile difference or distance between San Antonio and El Paso. So all the women who were trapped in that area of Texas would have no place to go. So first, we decided that we would build on the successful advocacy that we had established with the women in the Rio Grande Valley to try to develop this contextual analysis. And so one of the health outreach workers that we've worked with quite a lot, who's a lead organizer, we deposed her as an expert witness, and she was able to then surface all of the barriers that women in her community face, from poverty to immigration to the inability to take off work to go to a health clinic because doing so meant that lost wages, they couldn't arrange for childcare, they might get fired. So really trying to understand exactly what it was that women faced. And especially with abortion, and we'd already documented all these barriers in the context of preventive care, but with abortion there's the added barrier of stigma. So how does that play out for women in the community? And so the district court decision did find HB2 unconstitutional, and Judge Yickel, in his decision, incorporated this analysis about the practical impact, that you had to look at what was happening for women in these situations, not just women who lived in cities where abortion would still be accessible. And so he said that you have to analyze it in combination with these other barriers, like the ones that Lucy, the organizer, had named. So when this went before the Fifth Circuit, however, the Fifth Circuit judge during oral argument said, well, I don't understand what the big deal is about travel. You know, that travel from the Rio Grande Valley up to San Antonio, that's a really long, flat, uncongested highway with a speed limit that's relatively high. It just doesn't seem like that big of a burden. So we, of course, lost at the Fifth Circuit level and realized we have a lot more work to do to how to contextualize this. So we, for our Supreme Court case, we coordinated a number of amicus briefs, and one of the ones that was submitted in partnership with the National Latina Institute, who we've been working with, was drafted by an international human rights law professor who I don't think is in this room, Cindy Su, who many of you probably know. She's the director of the International Women's Human Rights Clinic at CUNY Law School. And she was able to include stories in the brief of Texas women who had tried to access an abortion and failed, or who had already experienced numerous barriers to accessing abortion even before this law was fully enacted. So an example is a woman named Bertha, who's a 25-year-old mother of two. She's from the Valley. She's in a very abusive relationship. And she had to arrange her visit to the clinic around the time when her abuser was not at home and when her kid was at school and when she knew that the abuser wouldn't be monitoring her use of the car. And so all of these things were carefully arranged. And for a woman like Bertha, it would be impossible to travel 150 miles to San Antonio to get an abortion if that clinic in McAllen had closed. So the brief also made comparative law arguments, arguing that in other countries around the world where courts have recognized a fundamental right, they've said that the state can't pass laws that infringe upon a woman's or anyone's ability to practically exercise that right. So we combined the stories with these arguments drawing from comparative law, as well as international human rights law. So we looked at the UN Human Rights Committee, which had made it clear that obstacles to safe and legal abortion can place women's lives at risk. And it's not just the law that's important, but it's also whether women have access to abortion in practice. So, I think in conclusion, what I would just say about using these human rights arguments in an amicus brief strategy is, first of all, it's really important because it helps to contextualize what the constitutional law standard can be. How can we interpret that? And it also puts the people who are most impacted by these laws at the center of the narrative, much like what Jamil was saying. So I think that there's two really important reasons to continue to do that.
Thanks, Katrina. And as you're describing this effort, of course, in the back of my mind is the importance of having an informed and an open judiciary who is ready to receive this information. And I just want to acknowledge Alice Henkin has joined us and the important work that she's done on judicial education and the importance of continuing to educate judges on the relevance of international human rights law and comparative law in U.S. courts. So I think maybe we'll pause there. There are many more things that I would like to ask, but I know that all of you probably have some questions. So maybe we'll take some questions, and as you're formulating your answers, as you're formulating your questions and as you're formulating your answers, one thing that I would love for you all to bring into this conversation is how everyone in this room can become involved, right? So we're all from organizations who are in a very privileged position to have this as part of our mission, to engage with international human rights standards and strategies to advance our work. There are lots of folks in the room who would perhaps like to become involved in this effort to use international law in ways to change U.S. law. And so maybe you can think about scaffolding that into your answers as you think about it. So we have mics available.
Hi. Thank you very much for a wonderful presentation. In terms of my question, obviously it's wonderful when a domestic forum is receptive to international human rights law. I was hoping you could talk a bit about when you encounter anti-international law pushback in domestic forums and how you confront that without creating further anti-international law backlash.
Great question.
You want to take more, or should we go?
Do you want to go ahead and ask your question?
My name is Claire. I'm proud to say that I've helped end the death penalty in 7 states, including right here in this room. In January of 2005, I reached the soul of the swing vote in New York State, and he came down and kissed me after I testified. So I'm proud of doing that. And my next focus, including the death penalty, is going to be solitary confinement. I think it sucks. I think it's sick. And how come isn't that obvious? Well, maybe because appellate judges are in solitary confinement in their chambers for at least 2 half days a week, and so they don't think it's a big deal. But I'm totally serious. Why don't we require judges and legislators who have to focus on voting on it to spend time in solitary confinement? I'm totally serious. How do they make a decision about something they haven't experienced? And by day 4, they'll probably be going nuts and saying, oh, we have to stop this. It's sick. I'm almost totally serious about this. So that's my suggestion.
Thank you.
Might it work? No?
There are other questions?
Hi, my name is Nikolai. I'm not a professional lawyer. I am from other side. I'm a professional client, probably, because I represent community of stateless people in the United States. And statelessness in the United States is probably the best example when domestic law does not meet international human rights standards. And what should be done in the near future for our issue to become the top priority for the US government and domestic human rights organizations? What strategy should be created and who's responsible for this action here in the United States? Thank you.
Thanks. So maybe we'll pause there. So some issues have come up. How do we confront and prevent backlash? How do we help contextualize human rights issues for the judiciary? How might we address issues of statelessness?
Okay, I briefly will try my best to answer some of them because they're really good questions. On the anti-international laws, there's actually a movement. It's been always a movement, organized movement, that is against anything that is international foreign law. Unfortunately, in recent years, we're seeing this movement using fear-mongering, using other kinds of particular political crisis or national security crisis in order to legislate and pass bills that prevent or prohibit state courts, particularly from just considering international foreign law. And it's very well connected also to Islamophobia, to anti-immigrant sentiments. I mean, it's not a coincidence that SB 1070 in Arizona and other bills, anti-Sharia, so-called anti-Sharia laws that were introduced in the last few years were more or less the same organized movement. So there is a movement. It's not only a resistance from judges, but it's also obviously that movement has a say in judges' appointments. Judges in some states, as you know, judges has to run for office, which is very problematic from a lot of reasons. But it's also come to a point where it was targeting Supreme Court justices. If you recall, a few years ago, even got threats, Justice Ginsburg in particular, for mentioning international law. But I would say that the way that we've been countering, first of all, was increasing education and raising awareness on why this has been a history of the United States of using and citing international law. From the foundation of the country, the United States was not as powerful as it is today. And maybe there was more reasons for the United States to use international law and cite international law to get recognition, maybe because of the fact that there's a lot of treaties, particularly with First Nations, indigenous peoples that had to be litigated at that point. But essentially what we're trying to do now is to say, first of all, this is not anyway foreign to the system. Whether you're talking about foreign law, examination or consideration of foreign law, it is first and foremost part of the U.S. Constitution, and its supremacy clause is very clear that ratified treaties are part of the supreme law of the land. And even if there's no enabling legislation, that does not mean that you cannot cite or you cannot use or you cannot invoke international legal obligations under ratified treaties. And there are really equal to common federal law, and they are even more important than when it comes to state law. Ratified treaties have a much more important constitutional weight. That said, I think in us talking about that, this is a process where we need to educate and engage with judges about that. more than anything else. Citing international and human rights briefs, doing it right, in the right cases, in the right fact patterns, not just in any case, not just throwing it in a brief or a complaint as a matter of, just a persuasive argument is nice to do, but is not enough when you're not backing it up. You have to assume that judges don't have the basic understanding of what are you really trying to achieve by citing what is the evolving standard of decency. How can you incorporate the concepts of torture, cruel, inhumane, degrading treatment in the Convention Against Torture and in the ICCPR into 8th Amendment litigation? And how do you do that, but relying on a different standard of setting, including sometimes soft law? The Mandela rules, which are the new revised rules of the United Nations minimum standard of treatment of prisoners, which were adopted and championed now with the United States, gives us as advocates and lawyers a chance to invoke international standards with regard to people in detention, not just prisoners in correctional facilities. It could also apply to detention, immigration detention. That gives us at least a new language, a new set of standards. Just like when you're trying to settle a case, you're looking at common practice. You're looking at good, compelling, parallel examples. And these protocols and soft laws, whether these are UN standards in different ways, you can always look at them in order to bring them into the litigation, even if you're not citing them directly. And I think, finally, just remember, Justice Kennedy has been influenced not just by the fact that he was reading those human rights briefs. He was meeting other international judges. He was going to the Salzburg seminar in Austria, and he was being asked and challenged by other peer judges from all over the world. How come you're deciding all your cases only under your Constitution and you're not looking outside the Constitution? That is one of the reasons why Justice Kennedy has evolved into thinking that there is also a way to think about human dignity as a good argument to be bringing to the conversation. Why he, in the 8th Amendment cases, he chose to do that. And even in the recent cases of the gay rights cases, if you read the New York Times article about it, it was also his understanding of the evolving social norms and social acceptance, but also with in mind of the influence that he had been getting from interacting with international counterparts. So I think all of that has to come into play in order to resist that movement. Thank you.
Reflections on those questions?
I mean, in response to the backlash question, I would also say that I think the best way to fight the backlash is to present a proactive vision. An alternative vision that is based on human rights. And so we've been trying to, we work in a lot of really difficult state contexts where they're not only hostile to international law, they're very hostile to reproductive rights, and with populations that face a lot of this backlash on a daily basis. So I think key to being able to advance an alternate vision is to be able to work like hand in hand with the communities that are most impacted. Working to develop a human rights organizing base, and then being able to frame a policy agenda that draws on human rights principles, again, principles of universality, participation, equity, transparency, accountability, and then link that to specific policy recommendations in the state is a way to use human rights without necessarily inciting as much backlash, right? Because you have people who are championing that policy agenda, and you're not saying the blue helmets are going to come, to Texas or Georgia or Louisiana and override domestic law. You're saying that this is that. What is the fundamental value that we're advancing here? I mean, we had in the middle of the Texas state legislative session last year when we were raising some of these concerns in a human rights hearing, we had numerous high-level state policy officials say out loud on the Texas floor, reproductive health care is a human right. And then you build on that, right? You hold them to account to that statement. So I think advancing a proactive vision, involving decision makers along the way, people who are your political allies, and obviously I'm talking about the political sphere here and not the courts, but I do think that's an important piece of this. And then I would say also just to the point about soft law, I just want to echo that because we use these documents all the time, and there are a lot of underappreciated documents that are coming out of these international bodies. I mean, for example, we work on eliminating racial disparities in maternal health, particularly in the South, where African American women die in childbirth at a rate 4 times that of white women, which we call a human rights crisis. And so we look to international standards on what does it mean to advance the right to safe and respectful maternal health care. What does that look like? Well, it turns out the Office for the High Commissioner for Human Rights has an enormous document, technical guidance that's informed by public health and international law experts all around the world that does just that and puts a human rights frame on how to instruct governments about how to ensure this right. So I think there are lots of tools that we can look to, and when we use that, again, we're informing a much broader policy agenda and an advocacy campaign around the domestic concern, but we're drawing upon international law to do that.
I would add, and I want to underscore what Katrina was talking about and the work that the Center for Reproductive Rights does, particularly in engaging the community, because I was struck when Jamil was talking about the concept of evolving norms. This is in the context of international law backlash, and that the concept of evolving norms, when you read particularly the Supreme Court decisions, it's almost as if there's the weight of influence and pressure comes from some external force, and they say, wow, they look up and they say, wow, the whole world has changed while we've been sort of sequestered in our chambers, and we have to be connected with these evolving norms. But it seems to me, you live on the planet long enough that you begin to realize that the concept of evolving norms, although most people think that it is an external process that happens without them, what evolving norms really are, it's a series of coordinated, carefully marshaled internal processes. It's a series of processes. So if you think about where people are in terms of antipathy towards international law right now, the idea is that when people are in a state of antipathy, that's when you really need to fight. That's when some people will say, well, we should, people are against it, so what are we going to make bad law? That's when you have to really fight. And when people are in a state of apathy, that's when you really need to build. And so the antipathy piece for me seems like the idea is that's when we begin to do a series of carefully marshaled, coordinated internal processes where people begin to change their particular view. And everybody's, as the dominoes begin to fall, everybody gets on board. It's just a human process that we have. And I think one of the key ways to do that is telling the real stories of real people that are affected in real ways by these policies. And the strategies that can be employed are like the strategies like the campaign, the strategies that I talked about in terms of beginning to move even death penalty lawyers to begin to consider that. And I think lastly, with respect to Claire's question, judges are like everybody else, except that we've created a structure. We've created a structure, and we all work in a structure in which they are allowed to consciously not experience the thing that we are advocating for because it makes them less partial. And the idea is that whatever experiences you can bring into that courtroom through briefs, through testimony, through video, begins to shift a range of folks. And practically, I just wanted to just touch on the practical question. Not everybody here works in an organization. Some people work in private firms. Some people work in legal services. One thought that I had was if some of these strategies seem really intriguing to you, while maybe the organizations here on the panel that we're all strapped for resources and we can't necessarily move as quickly in the directions that you want, but we all work with law firms because part of the emerging thing that is happening is that you can't do this type of advocacy, particularly around amicus briefs, without the help of law firms. So partnering with law firms on your on your question as a legal services lawyer could be a very positive thing. The other piece is when I was in law school, and that was before Gay got her first job in doing UN-based work, virtually nobody was studying international law. Right now, the summer is coming up. Any of you who have summer internships might want to think about bringing in some students that are actually conversant in this to begin to consult about how you might build out some of these strategies, or particularly the legal strategies, in the work that you're doing in individual cases or in the context of the other work that you're doing, in the place that you're in right now.
That seems like a very good place to end, and the fact that Joanne is standing here makes me think our time is probably up. But please join me in thanking our panelists for a really nuanced conversation. Thank you.
And because it's a CLE, we have to have more logistics. But if you're getting credit, please don't forget to sign out and get your certificate. And we will have wine and soft drinks and snacks now, so please stay. And we have some materials in the back if you're interested in talking about our committee or the Bringing Human Rights Home Lawyers Network that Risa mentioned. Please ask questions, or you can email any of us. Thank you very much.